Good afternoon. My name is Kim Stanger. I'm the head of Holland & Hart's Health Law Group. We're here to talk about collections, tips, and traps. After all, nothing says happy holidays like talking about collections. A little bit of background on this particular program today. We at Holland & Hart like to do these periodic webinars. This is a little bit different than some of them that I've done in the past. I'm going to basically be covering a kind of a potpourri of collection issues. The genesis is, it seems like recently we've been getting a lot of questions dealing with, for example, new payer tactics and avoiding payments and things like that. So I threw it all together and we'll address different questions, different issues that we've been seeing lately in the hope that it might be helpful for all of you. Along the way, I'll offer some tips that may help you in your collection process, as well as warning you about some of the potential traps, the federal statutes that may affect you in your situation. The program today is a bit like this map. Just as my disclaimer, we are not going to cover everything. We are going to cover a lot of stuff. In fact, we'll be moving awfully fast. But we're not going to be able to cover everything. In addition, a lot of the issues that we're going to talk about today are really dependent upon your particular state law. So it's important that you understand your state law as well as any additional federal laws that may apply to your particular provider status. So with that said, let's talk first about collecting from patients. The economic realities of such in the post of the Affordable Care Act are that patients still have a large percentage of the responsibility for paying their medical bills. If you believe the Obama administration, we actually have more insureds than ever before because of the Affordable Care Act. But we're seeing, and I'm sure you've seen, that patients are responsible for a greater percentage of those payments, either because they're involved in higher deductible or co-payment plans, maybe limited coverage, or simply the increasing costs of health care. Let's talk first, when we're talking about collections, go back to the basics. I have to go back to the basics quite a bit when I get these questions because people sometimes lose track of the basics. The fundamental premise is that a competent patient is generally responsible for the payment for the health care that you provide to them. That's a matter of contract. They came to you, you agreed to provide the care, they agreed to pay for the care, so you've got a contract with them. That contract could be oral, it could be a written contract. It's better if it's written, so ensure the patient signs the financial responsibility form. Also, make sure that the patient consents to the care that you're providing. If the patient didn't consent to the care that you're providing, then there's a question about whether or not they actually consented, whether or not there really is an agreement or an obligation for them to pay, and even if there is, they might sue you for lack of informed consent. Even if you don't have a formal written contract or no agreement, you may still be able to go after the patient for under a theory called equitable benefit conferred. So if you provided the care that was necessary for the patient or maybe one of the patient's dependents, you still may be able to collect from them even if you don't have a written agreement to pay, but it's always better to have that written agreement. Now, the exceptions for that are the patient may not be responsible for the cost if there was no agreement, they didn't consent to the care you're providing, or it wasn't effective consent, or it wasn't informed consent, or if you agreed otherwise. You might have agreed otherwise through your contract with an insurer or a network or a managed care program that you won't bill the patient, you won't balance bill, or the patient won't be responsible for certain portions of it, or maybe you participated in a government program that limits your ability to bill the patient. The general rule is the patient's responsible for this care unless you agreed otherwise. Well, what about minors? I get that question sometimes. What if the minor comes in? Is the minor responsible for the payment? Well, in most states, an unemancipated minor lacks legal capacity to contract for services. They don't have the capacity to contract. They can't bind themselves to pay for anything. And therefore, they may disaffirm the contract. You may send them a bill, and they may say, under the statute, I don't have to pay you. Now, in most states, there's some exceptions to that. If the minor is out on their own, living on their own and self-supporting, the statute actually gives the minor the capacity to consent and contract on their own behalf. Otherwise, they could never get necessary services, but that's not going to apply in most of your situations. So the bottom line is that generally, hey, a minor cannot validly consent to or contract for services. So if you're going to provide services for the minor, you better make sure you get paid up in front, or you make sure that you get parental consent, or you've got insurance out there that's going to pick up the cost. Well, what about the parent's responsibility? If the minor can't contract, can you sue the parent in order to recover the care of the minor? Well, in most states, the parents are generally liable for necessary care rendered to the minor children. So even if the parent wasn't there, the minor showed up, you provided the care, and it was necessary care, the parent still may be responsible for that care. You may still be able to sue and send them the bill, but you've always got to be concerned about whether or not you really had effective consent in that situation. If you didn't have effective consent, then yeah, you can send a bill, but they may say, you provided care without consent, and therefore, guess what? We're going to sue you, or we're going to refuse to pay the bill. So make sure that you've got appropriate consent. Well, what about a third party? Maybe grandma or grandpa or a cousin brings in somebody to receive care. Is that third party responsible for the care? Well, they are if they agree to be responsible. So the best thing to do is when you have that third party come in, make sure that they sign the agreement for financial responsibility, or you get the financial responsibility from another competent adult who can agree to the payment. Now, the law, it may be that there's a law or agreement that makes somebody else responsible for the cost of the care regardless of whether they sign up. That's, like the third-party insurers, where the third-party insurers have agreed to pay, or maybe it's a guardian or a person in the custody of the state. Maybe a police officer brings in the person for care. You can go ahead and provide that care because the state is responsible for the cost of the care, and you just want to document that. But the general rule is, hey, just because a third party brings in that patient to receive care, that doesn't necessarily mean that the third party is responsible for the care unless you get their agreement. And so you'll normally want to have them sign some kind of statement for financial responsibility. Well, so they're responsible for the payment. How are you going to collect on it? Well, you've got the informal collection process where the patient agrees, at least initially, and if they don't pay, then you've got the formal collection process. Let's talk about some of the steps through the informal collection process. The gist of this is the most important thing you can do is have effective payment policies. If you haven't got them, you should adopt, publish, and enforce your reasonable payment policies. And you should discuss those policies with the patient up front or their personal representative to make sure that they understand what those policies are. I like this quote that expectation minus reality equals frustration. If you explain what the policies are up front, then the patient is likely to have less frustration, less concerns, and therefore they're more likely to pay. So it's better just to get this stuff out in the open up front to make sure that the patient understands what your policies are and what their obligation is going to be. For example, you may want to state that the payment is due, including co-pays, at the time of service unless alternative agreements are made prior to the treatment. That the practice will file insurance claims as an accommodation to the patient, but the patient or the guarantor remains responsible for the payment if the insurance doesn't pay. And you got to be a little bit careful about that. We'll talk about that in a little bit, because it may be that if you submit that claim to the insurance company, you may be unintentionally binding yourself to some of the terms and conditions that that insurance company may place on that payment. So be aware of that. But generally, your policy should be that you'll file those claims, but you're doing it as an accommodation to the patient. We're not agreeing that we will only accept the payment made from the insurance company. Instead, the patient or the guarantor remains responsible for anything that the insurance company doesn't pay. You should make sure that statements are mailed at least every 30 days, and the balance will be sent to collections after whatever the appropriate period of time is, normally 90 to 120 days. Your payment policy should specify additional charges and fees that can be applied if those charges are allowed by applicable law and the appropriate payer contracts. We'll come to that in just a minute. But that might be things like late charges, charges for return checks, charges for missed appointments. If it goes to collection, collection costs and attorney's fees, and the like. You'll want to give the patient or their personal representative or guarantor a copy of those payment policies and get their signature showing that they agree to be bound by those policies. That should be part of your normal registration process. By doing that, it creates a contractual obligation, so you don't have to rely on this benefit of the bargain or benefit conferred or any equitable theories. You can sue them for breach of contract if they fail to pay. Now, let's talk about those additional charges. You need to check your state law as well as your payer contracts and federal law, I guess, for limits that may be placed on your ability to impose these additional charges. For example, it may be that your state law limits the ability to impose additional charges beyond the cost of the care that you provide. In Idaho, for example, we've got a provision that allows a provider to charge a late fee, but if they send that to collections, that collection agency cannot collect on that late fee unless certain conditions are satisfied. Other states have even more drastic or extensive limitations on the ability to charge for these additional fees in addition to the medical care that's provided. If you're dealing with Medicare, Medicaid, or payer contracts, they generally limit your ability to charge those additional fees because when you sign up with them, you agree that you're going to accept their payment or their rate as the charge to the patient. And so you can't make these additional charges. A lot of that's going to depend upon your particular payer contracts. You may want to look at the payer contract to see whether or not it will allow you to charge these additional fees. When it comes to Medicare, they generally won't allow you to charge things like late fees. They will allow you to charge for outpatient missed appointments if you bill the patient directly, not Medicare. There's actually a MedLearn on that particular issue that's on the screen. Well, what about refusing to provide care? After all, you guys are physicians, you guys are providers, you are healthcare providers, you have this ethical obligation to provide care to anybody, even if they can't pay, right? Well, that may be the ethical rule, but it's not necessarily the legal responsibility. In general, a provider has the right to refuse service to anyone, so you may generally decline services for non-payment. If they don't pay up front, you're not going to provide the services, or if you're in the midst of providing services, they stop paying, you generally are entitled to refuse to provide additional care subject to important limitations. First is if you're a hospital that's participating in Medicare, then of course you've got to be concerned about EMTALA. EMTALA requires you to provide a screening exam and appropriate stabilizing treatment, even if a person can't pay. But note that EMTALA states that you cannot delay treatment to inquire about payment. It doesn't say that you can't charge the patient or you can't try to collect from them. It just says that you can't delay the treatment or condition the treatment on the payment. So if you go ahead and provide the care, even under EMTALA, you can still try to collect from that patient after the fact. It doesn't prevent you from doing that. It's just you can't delay or condition at least that initial screening exam and stabilizing treatment on that payment. A provider generally can decline services for non-payment unless they've contracted otherwise. For example, you may have a managed care contract, or maybe some of your grant terms state that you will provide care to, a certain patient population, and if you refuse to provide care for non-payment or other reasons, that may be a contractual violation, but the key there is you agreed to it. You may want to check your contract obligations and make sure that they don't limit your ability to refuse to provide care for non-payment. And then also, of course, if you're a 501c3 or a recipient of federal grants, you probably have charity care obligations, which requires you to provide a certain level of uncompensated care or care to those people who may not be able to pay all of their bills. That doesn't necessarily state that you have to provide care to everybody, but a certain level of your care has to be, you have to make available for charity care. We'll talk about the 501c3 requirements a little bit later when it comes to hospitals. And the big rule on declining services for non-payment is you can't abandon the patient. Now, if you haven't begun treatment of the patient, you don't have this problem because there is no relationship yet, and you can require payment in advance. However, once you undertake that treatment, once that person becomes a patient, then you've got certain obligations, and you've got to continue to provide care to them. You can't abandon that patient without giving that patient an opportunity to transfer their care elsewhere without suffering some kind of adverse health condition. Therefore, generally, if you've got a situation, you're providing care, but that patient stops paying, or they never got around to paying the co-pays and you didn't collect it up front, well, generally, you can refuse to continue to provide the care, but you can't just terminate them cold turkey. You've got to generally give them advance notice. 30 days is standard, but it's not necessarily required. It depends upon the circumstances. You've got to give them advance notice that they need to transfer their care elsewhere, and then you've got to provide them with sufficient time so that they can effectively transfer their care someplace else. And in the meantime, you need to provide necessary care in the meantime. If you refuse to provide that care and that patient suffers an adverse action, they may, or suffers some kind of adverse outcome, then they may be able to sue you for a tort, patient abandonment, and recover any damages that they suffered. Even if they didn't suffer any damages, they still may be able to bring a claim against you under the Medical Practices Act or the relevant ethical standards in your particular state. So be careful about patient abandonment. Again, the key there is that you notify the patient in advance and give them a chance to transfer their care and provide necessary care in the meantime. Well, what about holding the patient's records hostage? That patient's not going to pay their bill, therefore we're not going to release your records until you bring your account balance, pay up your account balance. Can't do that. That would violate HIPAA. Under HIPAA, a patient has a right to access and obtain a copy of their protected health information, their record that's maintained in their designated record set. You cannot refuse to provide that record just because the patient hasn't paid their bill. There is no such exception under HIPAA. If you refuse to provide that information to the patient in violation of HIPAA, then you could be subject to those HIPAA penalties, which can range from anywhere from $100 to $50,000 per violation. If you do it with willful neglect, it's a mandatory $10,000 fine. It's not worth it, so don't hold the patient's records hostage. Now that's HIPAA. There may also be state law requirements that require you to transfer the patient's record. For example, in Idaho, it would be unethical for a physician to refuse to transfer the record to another physician if it's requested by the patient. Each organization should have their own financial hardship policies. There may be situations where patients can't pay their bill, and you should have your financial hardship policies in place. Why? Because if you decide to write off or waive a portion of their bill, having that financial hardship policy in place and complying with it may help you avoid any kind of a claim under the anti-kickback statute of civil monetary penalties law, like we will talk about later. If you are a 501c3 hospital, the Affordable Care Act requires you to have financial aid policies like we'll talk about in a little bit. When it comes to collections, just remember this. The likelihood of collecting decreases with time. Your best chance to obtain payment is right after, well, it's best before or right after you provide the services. The longer time you go after providing the services, the less chance you are going to have of actually collecting. Therefore, you need to take prompt action. That means send any invoices and submit claims promptly. Time the invoice if you can so the patient receives it before the first of the next month, because that's when most bills are paid. If there's insurance pending, include an explanation to the patient so they understand the status. Generate and review monthly accounts receivable reports. Your AR is probably your most important asset at your entity, and yet sometimes we have a tendency to just let that lag. Make sure that you're regularly reviewing your AR and following up. A sample follow-up schedule might be that within 30 days of the treatment, you send the first statement. Within 30 days thereafter, you send the second statement if it hasn't been paid. Then within 45 days, you initiate a phone call or a letter. As part of that, you may want to offer some kind of a payment schedule to them to make sure that you are getting paid. If they don't pay, then you may want to have a phone call or a letter advising them that the balance is going to be sent to collections within 14 days. And then if they don't pay within 90 to 120 days, you're probably going to want to send it to collections. We'll talk more about collections a little bit later. In those communications with the patient, when you call them, those are always uncomfortable situations, but you always want to be professional and be aware of the Telephone Consumer Protection Act. The TCPA applies if you use pre-recorded calls to a residence or pre-recorded or auto-dialed calls to a wireless number without the recipient's prior express consent. As long as you just pick up the phone and call the patient, probably not going to be a problem. But if you have some kind of pre-recorded message or auto-dialed message to cell phones, then you could run afoul of the Telephone Consumer Protection Act. There's a little bit of dispute about whether or not that would apply to your attempts to collect your own account But just to be safe, if you're don't use auto-dialed calls or pre-recorded calls. To the extent you are, then make sure you take a look at it and comply with the TCPA. That may mean making sure that as part of your registration policy, you get the patient's consent that would allow you to contact them via pre-recorded calls if you're really going to do that. All right. Prompt pay laws. A lot of states have enacted laws that require insurance companies or the third-party payers to go ahead and pay you within a certain period of time. Idaho's law is similar to most other state laws. It requires that the insurer must respond to a properly submitted claim within a certain specified time. If they've got concerns, they've got to notify you, and if you respond within a certain time, then the insurance company has to respond. The problem with these prompt pay laws usually is the penalties are really not very severe. In Idaho, for example, the insurance company can be liable to a relatively minor interest payment, but it's peanuts. It really doesn't do much to enforce the prompt pay law or to encourage compliance. More importantly, you can submit a claim to the Department of Insurance, and the Department of Insurance could come in and fine that insurer. That's probably the bigger stick in those situations. While we're talking about dealing with payers, let's talk about dealing with government payers. The bottom line here is if you're going to participate in federal health care programs, you got to comply with the rules and the regulations. Not only is it a matter of contract when it comes to the federal government, but they can also throw you in jail if you fail to comply with the regulations dealing with the submission of claims, coverage claims, balance billing, and the like. So make sure you know your state and federal rules when it comes to your government health care programs. You're probably familiar with a lot of those. We're not going to spend much time talking about those. We are going to talk about, however, dealing with private payers. When it comes time to dealing with private payers, remember this. Almost always, it's a matter of contract. It's a matter of what you agreed to do with the payer, what the payer agreed to do with you. If you agreed with the payer to, or in network with the payer, then you're generally going to be bound by the terms of your agreement. If you didn't agree, or if you're out of network, you didn't ever agree with the payer concerning any terms, then generally you're not bound by those payers' terms or conditions. It's a matter of contract, and if you didn't agree, then you're not bound. But you need to be aware of situations where you may unintentionally agree. You didn't know that you were agreeing, but you may be bound by those payers' obligations. For example, in the balance billing, let's talk quickly about balance billing first. General rule is if you have not contracted with the payer, then you may generally bill the patient for the whole amount or any balance due, as long as you make it clear to the patient that you are submitting the claim to the insurance company simply as an accommodation, but the patient remains responsible for it. On the other hand, if you contract with the payer or otherwise agree to accept the payer's terms when it comes to payment, that payer may be able to limit your ability to balance bill for covered services. So you need to check your contract to make sure that you understand what those rules are, what you agreed to. Now, even if it's, even under the most patient care contracts, most managed care contracts, you can still bill the patient for co-pays and deductibles and for services that are not covered by the payer contract, but you generally can't balance bill them for rates that are above or expenses that are in addition to the rates that you agreed to accept under the contract. So the question is whether or not you agreed to that. Now, there may be certain other conditions. For example, Medicare requires prior notice before you can bill the beneficiary for non-covered services. Just make sure that you're aware of what those conditions are. We've seen some recent payer tactics when it comes to this whole balance billing or requiring you to accept their terms. I wanted to talk about a couple of those just to give you a heads up on some things that you may experience. Some payers may place terms or conditions on the submission of claims in the documents that they provide to you. For example, we had a situation recently where a patient came in with their insurance card. They gave the insurance card to the person at the registration desk. They, of course, recorded it. They sent the bill out, and the insurance company sent back and said, on the back of that insurance card, there was a statement, and that insurance card said that by submitting this claim to the insurance company, you agree to the following terms and conditions or the terms and conditions that are set forth on the website. And they argued that by submitting that claim, you agreed to those terms and conditions, even though you didn't know what those were at the time, and therefore, among other things, you agreed to accept whatever rate it was that the insurance company was going to pay and not balance bill the patient. So you may have to look for, in correspondence with the payer, look for terms such as by submitting the claim to the payer, you agree to be bound by the payer's terms and conditions, or by submitting the claim, you agree to accept their payment in full, that there is no balance billing, or that you agree to their payment or appeals process. By doing that, they may say they've made an offer, and if you submit that bill, you're accepting that offer, and therefore you may be bound by those terms. So you may need to, I know it's uncomfortable, I know it's problematic, but you may need to be careful and take a close look at the insurance cards or the other communications with those payers to make sure that you are not unintentionally agreeing to or accepting terms that you never wanted to agree to. Now, in most of those cases, you are not necessarily, certainly you're not necessarily required to accept those terms if you don't bill the insurance company. Even in those situations, sometimes you can undo the deal if you return that money back to the insurance company and simply bill the patient. So in those situations, be careful about taking on those limitations or those restrictions that the insurance company may try to impose upon you unilaterally. A variant of that is what's called accord and satisfaction. This is actually a legal principle under the Uniform Commercial Code, which has been adopted in most states. And it states that if a patient or a payer tenders a check or other instrument as payment in full for the debt, so they give you this check, and maybe on the check they've written payment in full or settled in full, or they send you a letter and state by accepting this check or cashing this check, you are agreeing that this is in payment in full. If you do that, and if you negotiate that check, you accept that payment, then the provider is deemed to have accepted that offer as payment in full. So you can't collect the balance. So you have to be careful of these accord and satisfaction situations. Make sure that when you get paid by those checks that you look at them carefully to make sure it's not a situation where you are, by agreeing to that, you're accepting to payment in full. That could be, again, written on the check. It could be in a letter that's accompanying that payment stating that the acceptance of payment satisfies the debt. Now, at least under the UCC, the Uniform Commercial Code, and in most states, you may avoid accord and satisfaction prospectively by a couple of things. One is if you give your payers notice that to the extent that they want to try to accomplish this accord and satisfaction, they have to send that check or that notice, that request, to a certain person at a certain address, then they have to do that if they're going to try to attempt this accord and satisfaction. If they don't send it to that address, then it's not effective. In addition, most times the statutes will say, even when they try to do that accord and satisfaction, if you return that payment within a certain period of time, you can kind of undo that accord and satisfaction. Under the UCC, it's 90 days. The bottom line here is beware of accepting a check or a payment that's conditioned on you accepting it as payment in full, because if you accept it as payment in full, then there's a good chance that you're going to be bound by that. If you don't want to accept it as payment in full, then return it back to the payer and say, no, we're not accepting it as payment in full, and you owe us the full amount that's due. Another issue we've seen pop up recently deals with assignment. Now, you're familiar with assignment. Assignment usually occurs where the provider takes assignment of the patient's claim against the payer. The patient assigns to you the right to bill and receive payment back directly from the payer. That's good from you because you can get paid directly by the payer and you don't have to wait for the patient to get the money from the payer and then pay you. So it helps you. On the other hand, there is a risk associated with taking the assignment, and that is when you take assignment, generally you step into the shoes of the patient. That means that you're going to be bound by any contractual obligations that apply to the patient. So if there is a contractual obligation that says, hey, patient, if you want to dispute this claim or dispute the amount of the payment, then you have to go through this payment process or this appeal process, then that may also be binding on the provider who takes steps into the shoes of the patient. It's just like the patient. You take subject to their same rights and their liabilities. So you have to be careful about accepting assignments. Now, that's somewhat problematic because you may think, well, wait a minute, we're not accepting assignment. Remember, we signed that statement at the very beginning as part of our financial policies that state that we are submitting the claim as an accommodation to the patient, but the patient remains responsible in full. We're not intending to take the assignment. But if you look at your claims forms that you typically submit, at least the electronic or the paper claims forms like the UB92 or those forms, they state in there that you are submitting it and you are taking it under assignment. So be careful about this particular issue. It doesn't happen very often, but we've seen a growing number where payers are now starting to rely on this assignment argument to impose conditions on a provider that they never intended to accept. This particularly comes up in the context recently of ERISA employee benefit plans. By submitting the claim to the employee benefit plan that's covered by ERISA, the provider may subject themselves to the plan, terms, and conditions, even if you are not in network. There's actually some DOL regulations on this that basically state that if you submit that on behalf of the patient, then you are subject to the terms and conditions of the plan. Now, those terms and conditions of the plan may have very complex, cumbersome, or ambiguous terms or conditions concerning payment. So, for example, it may be that the plan administrator says, well, you're only entitled to Y dollars, even though you billed us for X dollars, we're only going to pay you Y dollars. And if you don't like it, then you've got a process under the plan to appeal that. But you as a provider probably don't know what that appeal process is. Nevertheless, by submitting that claim on behalf of the patient, you may be subjecting yourself to those terms and conditions. And if you fail to jump through those right hoops, you may have failed to exhaust your administrative remedies and therefore may be precluded from challenging that decision by the payor. So when you're dealing with ERISA plans, be careful about this. This is a growing issue that's out there, particularly because there's one or two companies nationwide that have gone into contract with payers. They've thrown out the prior payers' managed care contracts and unilaterally, and now are imposing these additional requirements. So beware of that. So what are your options to get around that? Well, one option is, don't rely on having to submit the claim through the patient. Instead, contract directly with the payer. Maybe you can get around it if you decide to, okay, we're not going to deal with the payer directly. We're just going to bill you, patient, and you deal with the payer. And you're responsible, patient, for the entire bill. If you get reimbursed from the payer for the whole amount, great. That, otherwise you're responsible for everything. Of course, the downside is that you have to deal directly with the patient and you don't get paid directly by the payer. It's kind of a damned if you do, damned if you don't situation, but be careful when dealing with ERISA plans. Let's talk briefly about medical liens. Most state laws have statutes out there that allow healthcare providers to file a lien to secure payment of medical bills. Now, usually they are not all medical bills. Usually they are related to tort recoveries. If you have a situation where the patient was in a motor vehicle accident or the patient suffered injury from another person called the tortfeasor, the person who caused damage to the patient. Well, that patient then has a right to recover damages from that tortfeasor. And these medical lien statutes generally will require or allow you to place a lien on the amount of money that that tortfeasor owes to the patient. So, for example, Idaho's medical lien statute, which is similar to most nationwide, states that the provider may obtain a lien on recovery from the tortfeasor for the reasonable charges of care to the patient. Note that the lien is not against the patient. The lien is against the tortfeasor, the person who caused the damage. Note that also it's against the person who caused the damage. It's not that person's insurance company. So it's the person who caused the damage who's ultimately responsible for paying off that lien. If you want to go after that person because in order to collect on that amount, then you have to make sure that you perfected that lien. In order to perfect that lien, the provider must file a statement of the lien with the county recorder within 90 days after the last date of service to which the lien relates. So you've got a time period in order to file that. If you don't file it timely and you let too much time pass, then after the last date of treatment, then you may not be able to file that lien, you may be time barred. That lien has to contain certain information, that statement of lien, particularly the name and address of the patient, name and address of the provider, the dates of service, the amount claimed, and the name of the persons liable for damages related to the injuries, if it's known. Note that that's the name of the tortfeasor, the person who caused the damage. It's not their insurance company, it's the tortfeasor. And then you have to mail a copy of that to persons claimed to be liable for the damages, that tortfeasor, within 1 day after the filing of the lien. So you have to file it, and you have to mail it to the tortfeasor within 1 day. Now, you may also want to send a copy of it to the tortfeasor's liability insurer just to let them know that, hey, there's this lien out there against any recovery that's going to be paid, but you need to make sure that you're sending it to the tortfeasor in addition to and not just to the liability insurer. Well, what's the effect of that? Well, their tortfeasor, or if they've got liability insurance, the practical effect is their insurer is obligated to pay the provider out of the proceeds of any settlement, or else that provider may sue the tortfeasor to enforce the lien. Note that they sue the tortfeasor, not the patient. So, because of that, the insurance company is going to want to make sure that they settle with any lien holders to make sure that their insured isn't going to get sued. Otherwise, the insured's not going to be very happy with the insurance company. To enforce that lien, the provider generally has to sue the tortfeasor within a certain period of time. In Idaho, they've got to sue within 2 years from the date the lien was filed. And if the provider is successful in that lawsuit, that provider can also recover their costs and attorney's fees. Now, important consideration here, this is an alternative to recovering your costs. This lien statute does not in any way, shape, or form excuse the patient's liability for the responsibility for the cost for the fees, the charges. You can still go after the patient. It just gives you another means to obtain payment for those services. One of the benefits of using this lien statute is you're generally not going to be bound by contractual payer charges. You can charge that tortfeasor whatever your usual rate is or your regular rates are, not necessarily the discounted rates you may give to payers. So you're generally not limited to the negotiated payer rate unless you decide to bill the payer directly. If you're going to bill the payer, then you're going to be bound by that contract. Otherwise, the argument is, look at payer, we're not submitting the claim to you for payment, we're submitting the claim to this other entity, this the tortfeasor, and we're not bound to only charge them the payer rates, they've got to pay us our regular rates. Now, there may be some limits in insurance company contracts, in your payer contracts, that may limit your ability to subrogate against or to sue in these tortfeasor situations. I've seen this argued recently where plaintiffs' lawyers have brought forth insurance contract provisions where the managed care payer actually limits the ability of you to pursue a lien against a tortfeasor if it would allow you to charge more than the contracted rates. So you have to make sure that you look carefully at your payer contracts in this situation. In addition, the plaintiff's lawyer out there, the patient's lawyer, is normally going to try to get you to reduce the amount of your lien so that it's more recovery for them and the patient. So some things they may argue is, I've seen them try to submit the claim to the insurance company on behalf of the provider. And if that insurance company then sends you the check, you negotiate or cash that check. The argument is you've either got a court in satisfaction or you agreed to be bound by the terms of that and you're agreed to abide by the payer rate. So one thing you may want to do is make sure that they are not authorized to submit claims on your behalf to the insurance company so that they can't bind you to that. They may try to limit your charges to the negotiated payer rate or state that your charges are not reasonable under the circumstances. That's just a matter of proof. If they're reasonable, if it's your reasonable rate, then you can go ahead and charge them. It doesn't matter what your payer contract is. At least that's the argument. They may want to reduce the amount of the claim due to limited insurance coverage. Maybe there's multiple persons involved or the damages exceed the amount of the insurance coverage, so they may come back and say, look, it reduced the amount of your claim because this guy's only got a $25,000 insurance policy and yet the bills are, $100,000 for multiple people. You're not going to get paid your whole thing anyway, so negotiate and accept only a portion of it. That's a business decision for you, whether or not you want to do that. Sometimes the attorneys will come back and say, look, we secured this settlement for you, therefore you owe us money for securing that for you because you got the benefit of the work that we did, and therefore you have to pay us a third of the amount of money that you recovered from that. General rule, at least in Idaho, is no, they're not entitled to that. They didn't perform those services on your behalf. You never agreed to pay them, and therefore there is not this equitable subrogation theory. All right, let's talk briefly about guarantors. If you've got a patient that comes in there, you have questions about whether or not they're going to pay their bill, or maybe you provided the services and they haven't been able to pay their bill, you may want to look and see if you can get a guarantor on their account. Generally, any competent person may serve as the guarantor. It's a matter of contract. You just want to make sure that you have a contract whereby that guarantor agrees to guarantee that that bill is going to be paid to you. Now, that could be an oral contract. It could also be a written contract, but of course, we like the written contract much better because it avoids problems down the line. So you generally want to make sure that that guarantor executes any written agreement that they're going to be bound. The terms of that agreement should specify that it allows you to recover from either the patient or the guarantor. Sometimes they'll try to revise it, or you'll see a form that will say that you can only collect from the guarantor after you try and collect from the patient and the patient doesn't pay. You don't want to do that. You want to have your right to go after either the patient or the guarantor because it allows you to get paid more quickly and avoids disputes. You should make sure that it confirms you're not required to exhaust a claim against the patient first. Make sure that it includes any additional charges you're going to pay or require that they pay, like late charges, missed appointments, and the like, to the extent that it's allowed by applicable law. And in certain circumstances, if it's a large bill, you may want to consider requiring some form of security, whether that is some kind of an interest in some kind of specific property or whatever it might be. Well, what about payment plans? Well, maybe you've got a patient that comes in and either in advance you decide that you're going to allow them to make payments over time, or maybe you've incurred this debt, you provided the care, but they're not able to pay. They come back and they want to do a payment plan for you. Can you do that? Sure. You can allow the patient or the guarantor to pay over time, but you're probably going to want to require a formal payment contract. That's safest. That would normally include a written agreement along with a promissory note. And in a significant situation, you may want it to include a security interest, whether it's against their home or whatever else might be. You would want to specify an interest, finance charges, and late fees. You may want to require a guarantor if you haven't otherwise got a guarantor yet as part of that payment plan. Require them to get a guarantor. One thing you may want to do is, if it's a situation where you try collection efforts, this person isn't paying, they want to come in with a payment plan, you may ask them or agree to them to get a stipulated judgment or withheld judgment, a consent judgment, so that if they fail to pay, you can automatically have this consent judgment signed by the court, and you can execute on it without having to go through a full trial or process in order to be able to execute. That would probably be a rare situation, but if other situations, other attempts to collect have failed, it's a significant debt, that is an option that has worked well for us in the past. Now, if you are going to allow payment plans, beware of becoming a creditor under federal and state law. So beware a regular practice of allowing payment plans, especially if you set that up in advance, so before the patient even gets treatment, because doing so may subject the provider to federal and state laws governing those who extend credit. It may make you kind of like a bank, including it may subject you to the Truth in Lending Act, the Equal Credit Opportunity Act, or state laws affecting the extension of credit. For example, the Truth in Lending Act states that if you extend credit, it applies to those who extend credit more than 25 times per year, and if you impose finance charge or a written agreement allowing payment in more than 4 installments, then you've got to, along with that credit transaction, you've got to provide certain disclosures that are set forth in Regulation Z. If you fail to do that, you can get hit up with a bunch of penalties. Under the Equal Credit Opportunity Act, that's basically an anti-discrimination statute, so you can't discriminate in the offering of credit. It applies to creditors who regularly decide whether to extend credit unless the credit is not subject to a finance charge and not payable by a written agreement in more than 4 installments. basically you can't discriminate and you have to satisfy certain requirements that are set forth in this regulation. Also, the bottom line there, if you've got a regular practice of extending credit, make sure you're familiar with these laws because you may be subject to them and you don't want to get hit up with those additional fines and penalties. All right, what about self-pay discounts? I get this question quite frequently. Hey, can we offer self-pay patients a discount? Don't we have to charge all patients the same rate? We can't give any special deals to any particular patients. That is generally not the case. Providers may generally charge different patients or payers different amounts. Isn't that exactly what the payers are doing with you? They're coming back in and saying, hey, we want to negotiate a different rate for you. Yeah, you can negotiate different rates for different patients or different payers subject to certain limitations. And those negotiated rates could include discounts for self-pay patients. What are those limitations to negotiating different rates for different payers? Well, you can't do it based on illegal discrimination, for example, race, sex, religion, etc. If you are a hospital and you're submitting cost reports, there is some statements in the Medicare claims manuals or the reimbursement manuals that suggest that they want some kind of a uniform payment process, and if you get too far out of whack with that, then they may look askance at your cost report, although I don't think I've ever seen that enforced. In some states, payer contracts may contain what's called a most favored nation. So you may contract with the payer so that you agree to give them the best rate that you're giving anybody else, the same rate that the best rate that any of the persons are getting. And therefore, if you're giving patients a self-pay discount, you have to give that payer the same discount. Now, I think in most states, they actually outlaw those most favored nation clauses. For in Idaho, for example, those most favored nation clauses are outlawed, so you don't need to worry about that. But if you offer the self-pay discount rates, it may affect your usual and customary rates to the extent that that is relevant. Now, that usually becomes most relevant because of the Medicare substantially in excess rule. The Medicare substantially in excess rule states that a provider may not charge Medicare substantially in excess of the provider's usual charges. So then the question is, what are your usual charges? Well, we've received guidance from the OIG as recently as 2015 in an advisory opinion. The test of whether the provider charges more, the test of what, whether you're charging substantially in excess is whether the provider charges more than half of its non-Medicare Medicaid patients a rate that is lower than the rate it charges Medicare. So you'd look at the median and see, okay, what are we charging non-Medicare patients? If you're charging Medicare more than that amount that you're charging half those non-Medicare patients, in that situation you could be in trouble under the substantially in excess rule. Now, the OIG has stated that it would not use that rule to exclude or attempt to exclude any provider or supplier that provides discounts or free services to uninsured or underinsured patients. So if you really have a situation where it's you're offering discounts because of financial hardships, those types of things, that's probably not going to create a problem for you. On the other hand, if you're out there negotiating with private payers or other entities for these discounted rates, that could affect your usual rate for purposes of the substantially in excess rule. That seems to pop up a lot lately with negotiated rates concerning lab tests, so be careful about that. Waiving co-pays and deductibles. Maybe you want that patient to pay, so we'll say, okay, I'll tell you what, we will waive your co-pay and deductible, we'll just do insurance-only billing. Bottom line is that is usually a very bad idea because it can violate state and federal laws. In addition, it's probably going to violate your payer contracts. The government has specifically identified red flag situations if you're waiving co-pays and deductibles. The theory is if you're waiving those co-pays and deductibles in order to induce program business, to invite people to come to you because we'll only do insurance-only billing, in that situation, that would violate the anti-kickback statute and the civil monetary penalties law. In addition, if you're offering that benefit, if you're waiving co-pays and deductibles to physicians or physician family members, it would also likely violate Stark. Well, the government has said, at least with regard to federal program beneficiaries, you may waive or discount government co-pays or deductibles if you satisfy the following. If you're offering that not as part of any advertisement or solicitations, you're not out there advertising insurance-only billing, You do not routinely waive copays and deductibles, and you waive or discount that copay or deductible after a good faith determination that the beneficiary is in financial need, or you've tried to collect and you can't collect on it. If the patient simply can't pay because of financial need, or you tried to collect and you can't collect on it, in that situation, if you document such, then you can go ahead and waive the copay or deductible. The key there is you are not using it as an inducement to get additional services. You need to document this financial hardship or your efforts to collect. The government has suggested you should document factors in determining financial hardship, such as the local cost of living, the patient's income, assets, expenses, the patient's family size, the size of their bills, to make sure that it's not just this wink, wink, nod, nod, hey, we've got this financial assistance policy that we're going to provide to everybody regardless of their true financial condition. The government also said that if you've got somebody you're working with on that financial assistance policy where you're waiving copays or deductibles or the like, you should re-examine those factors periodically to make sure it's still appropriate to allow them to participate in that. If you're a hospital, the government has a specific anti-kickback statute safe harbor that applies for certain inpatient hospital stays. You'd want to make sure you comply with that. Remember that those are federal program beneficiaries, also state program beneficiaries, but your state may have additional laws that limit your ability to waive copays or deductibles. For example, Idaho has a specific statute that prohibits engaging in a regular practice of waiving, rebating, giving, or paying all or part of a claimant's deductible for health insurance. You can get hit up with a $5,000 fine if you're doing that. Note that your state laws may actually be broader than the federal statutes. The federal statutes normally apply to government health care providers, Medicare, Medicaid, those types of situations. Your state law may be broader. It may apply, as in Idaho, like Idaho's does, to any payers, including your private payers, your private insurance companies. Even if you're not worried about the statute, almost certainly your payer contracts have a provision that require you to collect copays and deductibles, and if you fail to collect the copays and deductibles, you're going to be breaching the payer contract because that's going to screw up their whole actuarial basis, and therefore they could get you for insurance fraud or a breach of contract at the very least. All right, what about if you're not going to write off just copays or deductibles, but you're just going to write off the whole bill? Can you do that? Well, again, you got to be worried about the fraud and abuse laws if you're doing that in order to induce referrals, or you're doing that for referring physicians, or you're going to violate state laws. The bottom line there is, however, if you make a separate good faith determination that the beneficiary has a financial need, or you've tried to collect and you can't collect, in that situation, you're going to probably be justified in writing off that patient's bill. When you're talking about writing off the patient's bill, writing off the entire bill is certainly less risky than writing off copays or deductibles because you don't have necessarily the same civil monetary penalties concerns or the same private payer contracts. If no payer is going to be billed for the services, then generally the third payer doesn't care whether you write off that bill. If you write off only the copay or deductible, however, again, you can run afoul of the federal fraud and abuse laws as well as your private payer contracts. For those of you who are 501c3 hospitals under the Affordable Care Act, it requires you to put in place a written financial assistance policy that satisfies certain criteria. In addition, you've got to limit the gross charges to qualifying patients, those patients who are qualified under the financial assistance policy, to not more than the amounts that are generally billed to individuals who have insurance as defined in the regulations. And you've got to make a reasonable effort to determine the eligibility for their financial assistance. That financial assistance policy has to include certain criteria, including eligibility criteria. It's got to explain how patients can apply for the assistance, how they can be charged for their care, and that you have to provide emergency care regardless of their eligibility for financial assistance. One of the requirements is that you cannot engage in extraordinary collection actions prior to making a reasonable effort to determine their eligibility for financial assistance. Extraordinary collection actions are things like selling that debt unless certain conditions have been satisfied, so you can't transfer it over to a collection agency. Certain credit reporting actions, deferring or denying medically necessary care due to unpaid bills, legal actions, certain other things you've got to satisfy. If you're a 501c3 hospital, you need to make sure that you're familiar with those new 501R rules that just came out in December of 2014. This isn't in your handouts, but just real briefly, I wanted to touch on professional courtesies. Professional courtesies are those situations where you may just decide to write off the bill of a referring provider or their staff or their family members, things like that. The bottom line is, hey, you can get in trouble there if you're extending those professional courtesies to referral sources. That may violate the anti-kickback statute if one purpose of that professional courtesy is to generate referrals. It could also violate the civil monetary penalties law if you're doing it in order to induce referrals by program beneficiaries. It will violate the Stark law if you're offering that professional courtesy to referring physicians or their family members, unless you structure that deal under Stark to satisfy certain safe harbors. There's a safe harbor for professional courtesies. The bottom line here is you've got to have a written professional courtesy policy that has to be offered to all providers in that particular area. It's not based on the referral patterns. You've also got to have a medical staff before you can do this. So for you solo practitioners, don't do any professional courtesies to referring physicians because you're not going to be able to satisfy Stark. If you have a professional courtesy policy, never ever have it just relate to insurance-only billing, because that's almost certainly going to violate the laws as well as your payer contracts. Maybe sometimes you offer free items or services to your own employees as either a professional courtesy or part of your employee benefits plans. Just make sure that if you're doing that, you understand the consequences or you consider that. That may result in tax benefits to your clients, so those benefits may actually be taxable and you may have to withhold taxes for those benefits. In addition, it may run afoul of your employee benefit laws, and so you need to make sure that that is consistent with your plan. You may want to touch base with your ERISA attorney on those issues. What about prompt pay discounts? Can you offer prompt pay discounts either to the entire bill or to co-pays or deductibles? Well, the bottom line is if one purpose of offering that prompt pay discount is to generate improper referrals, well, then you've got problems under those federal fraud and abuse laws. But the government has said with regard to government beneficiaries, Medicare and Medicaid beneficiaries, you can do prompt pay discounts if the amount of the discount relates to the voided collection costs. So you're doing it simply to avoid the collection costs, not to induce referrals. It's offered to all patients for all services without regard to the patient's reason for admission, length of stay, or DRG. It's not advertised so as to solicit business. You notify the private payers of the program, and the costs are not otherwise passed to Medicare or Medicaid. So prompt pay programs that satisfy those requirements are going to be okay, at least for Medicare or Medicaid patients, at least under federal law. Private payers, can you do it? Well, you generally cannot discount copays and deductibles without violating your managed care contract unless you contact the payer and the payer otherwise agrees. Otherwise, you're going to be violating those provisions that say, hey, you're required to collect the copays or deductibles. In addition, prompt pay discounts may adversely affect your usual and customary charges to the extent that that's relevant in your contract. And the payers may claim the benefit of the discount if the insurer pays within the relevant time. So if you're offering that to self-pay patients or other patients, the insurer may come in there and say, well, gee whiz, we're entitled to that prompt pay discount too. So the bottom line is check your payer contract or contact your private payers if you're going to engage in those prompt pay discount situations. All right, a new issue that has come up recently is it may be a situation where it's cheaper for you to pay the patient's insurance company in order to maintain that insurance for the patient, so that that insurance company continue to pay the patient's bills. So there's this at least option now that some people are considering, some providers, that they want to pay the patient's health insurance premium or COBRA benefits to main insurance because it allows them to essentially net a profit. What are the rules there? Well, if you're paying Medicare Part B, C, or D premiums, the anti-kickback statute's implicated because you may be offering this incentive in order to induce the provision of additional services. In addition, it may violate the civil monetary penalties law, but the OIG has approved those types of situations where they pay the premiums In this particular case, it involved a Part B premium for an ESRD patient where the patient was already receiving the services, so it was unlikely to induce services that might otherwise be received. There was no inappropriate patient steering to particular providers. The patients were not coerced into enrolling in Part B, and certain protections were built in to protect the Medicare program. Now, this was limited to this particular program. The OIG cautioned that it might reach different results in other circumstances. So before you go out and start paying that patient's Medicare Part B premiums or other programs that are covered by federal health care programs, make sure that you consider the federal fraud and abuse implications. Well, what about if you're paying the premiums for the patient to participate in the health insurance exchange? Can you do that? Is that a federal program? This is an interesting situation that just came up relatively recently. Initially, the Secretary Sebelius at the time said, no, you can go ahead and do that. HHS about a week later came back and said, oh, wait a minute. No, we don't want you doing that. They issued a letter in 2013 that said HHS has significant concerns with this practice where you're paying the patient's insurance premium so they can participate on the health exchange because it could skew the insurance risk pool and create an unlevel playing field in the marketplace. Therefore, HHS discourages this practice and encourages insurers to reject such third-party payments. HHS intends to monitor this practice and take appropriate action. As far as I know, they haven't taken further action, but a lot of the insurers now are prohibiting third parties from paying, or providers at least, paying these insurance premiums. So you've got to be careful about that situation. It may not be illegal, but it may violate the payer requirements. Well, what about if you're paying the private insurance premiums like COBRA or other items? You can probably do that. It probably doesn't implicate the anti-kickback statute or the civil monetary penalties law. The COBRA regulations appear to contemplate that COBRA premiums could be paid by third parties, but you should check your state laws and the payer contracts to make sure that it's consistent with applicable law. Now, this is a developing area of the law. You may want to stay tuned to the developments in this if you're going to do this on a regular basis. All right, I'll try to go through the rest of this stuff relatively quickly. Let's say you've tried your own collection efforts, the patient's not going to pay, you decide you have to send it to a collection agency. That's okay, but make sure that you consider before sending it to the collection agency. You may not want to send it to the collection agency if the balance is small or if the case involves a bad outcome, because quite frankly, you send it to the collection agency, what's the patient going to do? They're going to start considering a malpractice claim against you. And under the circumstances, the benefits that you get simply may not be worth the cost. So before you send any claim to collections, make sure that you review it to make sure that it's appropriate and it's not going to result in problems to you. If you are going to send it to a collection agency, don't use this guy. Why? Because if you do, there is a chance that you could be held liable for what they do under the Fair Debt Collections Practices Act. Now, the Fair Debt Collections Practices Act generally applies to collection agencies, not entities that are trying to collect their own debt. But if you engage that collection agency and that collection agency is acting as your agent rather than an independent contractor, there is a possibility you could be held liable. Also, you could be held liable if you threaten or make a misrepresentation that you're either not who you say you are or that you're getting a collection agency involved when you're really not getting an agency involved. In that situation, it may trigger the Fair Credit or the Fair Debt Collections Practices Act. What does that act require? It basically prohibits collection agencies from engaging in certain conduct that appears to be too extreme or is too annoying or too harassing. If you fail to comply with that, you could get held up with private lawsuits or actual damages and costs and attorney's fees. Remember, if you're going to engage a collection agency, they're probably going to be acting as your business associate, and therefore you're going to need a business associate agreement with them. HIPAA does not prohibit you from disclosing information to collection agencies because that is part of your healthcare operations or payment purposes. So long as you haven't otherwise agreed with the patient, you're not required to get the patient's authorization to disclose their information to a collection agency because, quite frankly, that would be stupid to require you to do so. But so under HIPAA, you can go ahead and disclose information to the collection agency. If you have a business associate agreement in place, just make sure you don't disclose more than is minimally necessary. Remember, under HIPAA, you can be liable for that business associates misconduct. If you know they're out there screwing up with that patient's protected health information and you don't take action to stop it, or if that collection agency is determined to be your agent, you want to make sure that your agreement with that collection agency confirms that they are not acting as your agent, that they are an independent contractor so that you're not liable for what they do. You may want to periodically review the collection agency's practices to make sure that they really are above board and that their misconduct is not going to come back and hurt you. What about reporting to a credit agency? Maybe that patient has really made you mad, so you're either going to threaten or you're actually going to report them to the credit agency in order to convince them to pay. You can do that, but just make sure that it may expose you to potential other liability, including the suit for damages if you report the information falsely or report inaccurate information to the credit reporting agency. Could also subject you to liability under the Fair Credit Reporting Act or the Fair and Accurate Credit Transaction Act. Potentially could affect you under HIPAA if you're disclosing more than you should under the HIPAA situations. All right, let's say you've gone through all of that. You've decided that we're done with it. We're going to go ahead and sue the patient. That's always an option. You can go ahead and sue. You bring your lawsuit typically in state court. It could be in small claims court if it's under a typical dollar amount, usually $5,000. In Idaho, it's $4,000. The benefit of small claims court is no attorneys are involved in that, so you can handle it on your own. If it's a higher amount, you'll probably have to get an attorney to help you. Before bringing that lawsuit, make sure you consider the costs, including the potential for a retaliatory malpractice claim or other claim, bad publicity, your cost and inconvenience of being a party in a lawsuit, and the potentiality for actually recovering money. Because remember, you generally can't recover squeeze blood out of a turnip. And if that patient doesn't have money, they don't have money, and it's not worth going through the cost and the expense of litigation. Now, if you determine that they do have assets and you want to go ahead and pursue it, you presumably get the lawsuit. If you win, then you don't automatically get the check. If they refuse to pay, you can go ahead and garnish their wages or attach certain property or foreclose on property. But those are additional processes that you have to go through, and you have to weigh that into the factors or the costs that you evaluate before pursuing the claims against the patient. If the patient files bankruptcy, stop any further collection actions immediately. You should get involved in the collection agency, or excuse me, the bankruptcy matter. You will submit your claim, and then your claim will be resolved along with the bankruptcy, the other creditors in the bankruptcy. If you get notice of that bankruptcy and continue to in your collection actions, then you could violate the automatic stay, and you could be hit up with a whole bunch of fines and penalties, and you don't want to go there. Can you recover the costs and fees of collection? Well, generally, if it's part of your contract, and there's not a law to the contrary. So you may want to include that in your contracts. Even if it's not in your contracts, your relevant state law may allow a successful party to recover their costs and fees. In Idaho, for example, if it's a commercial transaction, you can recover your costs and fees. But again, that's assuming that the patient has money in order to pay you. All right, in my final couple of minutes here, let me just run through some suggestions for collection practices. Remember that the patient is generally responsible for payment unless you agree otherwise. Beware of situations where you unintentionally agree otherwise by submitting the claim or accepting the terms and conditions of the payer. If you do, then you're bound by those other agreements. You should establish your appropriate collection policies, train your staff concerning those policies, use appropriate staff persons to handle collections. That requires persons with unique skill sets who can interact appropriately with the patients and hopefully avoid confrontation so that you have a greater likelihood of getting paid. Remain polite and professional in your interactions. Explain your payment policies up front, including using things like payment due upon services signs, notices or brochures, discussion by staff concerning your patient requirements. Identify the payers or guarantors up front so you know how you're going to get paid before you agree to provide the services. Obtain the necessary pre-authorizations before you actually provide the services. That lets you know whether or not you really want to provide the services. Identify the non-covered services up front so the patient understands what the obligations are and you understand what the patient is going to be responsible for to see whether or not you really want to proceed. Obtain and maintain updated legible information from the patient so that you can always go after them if you need to. Remember, again, expectations minus realities equal frustration. Make sure you discuss your payment policies and practices with the patient in advance. If possible, explain what insurance will or will not cover at the time of service so the patient knows what to expect. That generally requires you to contact the insurer in advance so you know what the coverage is. So you can discuss that with the patient. Then you discuss your payment options. Collect the payment up front, whether it's self-pay, co-pays, deductibles, or any open balances. Accept credit cards. Arrange for alternative payment methods if you need to. That could be a payment plan, a security agreement, in rare cases probably, a guarantor. In some situations, maybe there are government or community programs that can help pay for indigents or others. Some providers will go out and make arrangements with local banks so that they will provide loans to patients who have significant medical bills. There are credit card or financing companies that will now work directly with providers so that they will offer this credit card, medical credit card, for patients who need health care. You may refer them over to a resource to help them get signed up for the health insurance exchange so that they can get coverage. So think outside the box on looking for other alternatives for the patient to be able to pay. Considering offering cash discounts for payment up front or a prompt pay if it's consistent with the federal, state, and anti-kickback or similar laws. That's stuff that we talked about prompt pay discounts. Require the patients to visit or pass the registration or collection desk before leaving so that you can catch them and make sure that they paid. Better yet, make sure that they pay before they go back in for the service. Remind the patients of unpaid balances at the time of their appointment, so before they come in that they will pay so that you don't have a situation where you get further in debt. Charge fees if it's permitted for things like missed appointments, bounced checks, finance charges, late payments. Make sure that you check with the relevant payers. If it is a personal injury case or other situation where a lien is permissible under your state, file that lien. Make sure you file it on a timely basis and give the proper notice for it. Ensure your bills are clear and understandable. Send the bills promptly. Promptly follow up on delinquent accounts to patients or third-party payers or guarantors. Use appropriate methods in your interactions. Review the accounts receivable regularly. Review claim denials and adjust processes accordingly so that you don't have these continuing claim denials, which is going to bog down your accounts receivable. Before starting the formal collection action, consider the cost of that collection action. Is it worth it to you? The likelihood of payment, whether this is truly a hardship case that you want to invoke your policies, a potential retaliatory malpractice claim, negative publicity you have, or regulatory concerns with write-offs. In everything you do, make sure that you're professional in your collection activities so that you don't get hit up with either state, federal, or private claims for improper conduct, and document appropriate collection activities. As appropriate, send the claim to the collection agencies. You usually want to do that sooner rather than later. And before you pursue any kind of litigation, make sure you consider the costs. That is it. I realize I covered an awfully lot of stuff and I talked awfully fast. It is not comprehensive, but hopefully it at least gives you a heads up of some of the collection issues that are out there. We will be continuing our Health Law Basics webinar series in 2016. Actually, in December next week, we've got one dealing with OSHA and healthcare that you can sign up for. In January, we focus on fraud and abuse issues, including STARK, anti-kickback, civil monetary penalties, law, and responding to noncompliance. February is our HIPAA month. We're going to be talking about different HIPAA issues in case any of you have to do a self-report by the HIPAA deadline, which is 60 days after the end of the year. So if you're interested in that, you can go onto our website, sign up to participate in those webinars. If you would like to receive copies of our Health Law blog or alerts, including alerts of future webinars, and you are not already receiving that, send me a quick email. We will go ahead and add you to that list. And that is it. If you have questions about this stuff, you can use the chat feature and send that to me or shoot me a quick email, and I will try to get back to you as quickly as I can. Otherwise, thank you very much for your participation, and I hope that it has been helpful. I hope that you all have very happy holidays.